No, that has to be division bench. It can't be by single. List has to be rectified. Yes, you can make a mention because there is a mistake in the listing. The judgment is by division bench, wrongly listed. Huh.
Lordship, I'd like to mention item 9 on behalf of S. Chang, government advocate. We are yet to receive instructions, so we'll wait for 3 weeks, Your Lordship.
Item 9.
Yes, Your Lordship.
You're making prayer on behalf of the government.
Yes.
Okay.
Yeah, S. Chang.
Both sides are represented on the prayer made by an government advocate. List after 3 weeks so as to enable the state to file affidavit in opposition in the matter.
Yes, let me
Okay.
receive it. Your Lordship, I also have a similar prayer for item 11.
11.
Yes.
You've informed the other side?
Yes, I've informed the party. He was here just now.
Okay. Both sides are represented on the same order. List after 2 weeks.
3 weeks, Your Lordship.
Okay, 3 weeks. Okay.
And also have a similar prayer for item 14, 1 4.
You've taken consent?
I could not locate them, Your Lordship.
No ex parte.
Okay,
You renew the prayer when the matter is called.
Lordship.
May I please? Lordship, I beg to mention item number 2. In this matter, Your Lordship, I 1, 2, and 3. If 2 weeks' time can kindly be granted to file my counter affidavit.
1, 2, and 3.
Yes, 1, 2, and
Okay, you're there.
Your Lordship.
Okay.
Ako,
Both sides are
respondent number
represented.
4 and 5. Your Lordship. I'm for respondent number 4 and 5. Your Lordship may kindly grant 3 weeks to file affidavit in opposition.
3 weeks. Okay, both sides are represented on the prayer made by learned government advocate as well as the learned counsel for respondent number 4 and 5.
Yes, Your Lordship.
3 weeks time is granted to file affidavit in opposition in the matter. List after 3 weeks.
Thank you, Your Lordship.
Lordship,
Yes,
Lordship, item number 6, Lordship.
yes.
Lordship, here I'm for the respondent number 8,
Okay,
the insurance company. Lordship, I have instructions that the insurance company may not be a necessary party. Let me be allowed some 3 weeks time to file an appropriate application, Lordship, for deletion of my name, Lordship. Item number 8. Item number 6,
6.
I'm for the
Okay,
8.
both sides are
Insurance
represented. Mr. P14 Honored Counsel for the
Right.
respondent number 8 submits that the said respondent is not a necessary party and therefore he has instructions to file an interlocutory application in this regard. This matter stands adjourned today. List after 2 weeks,
3 weeks, Lordship.
3 weeks. Okay.
Hello, Lordship.
Yeah, please, Your Lordship, I beg to mention item 1, Your Lordship. Here, I'm making a prayer on behalf of my colleague, Your Lordship. She has received the affidavit in reply this morning. So this matter may be listed, since the pleadings are complete, Your Lordship, this matter may be listed for hearing the usual course, Your Lordship.
Yes, item number 1. This is a case of regularization.
Yes, Your Lordship.
We'll take it up next week in the
Your Lordship.
admission stage only.
Your Lordship, I've been informed that in a similar matter, the division bench has taken up that matter and the matter is kept CAB, Your Lordship, so this matter would.
No,
also-
you see, these matters can't be adjourned like that. When somebody is claiming regularization. If the judgment comes in the meanwhile, that will be the law which will have to be followed. But for that, we can't postpone
This is a retrospective regularization.
whatever
So-
be, but we are not, these matters are not being posted for regular hearing. Next week.
What's the 2 weeks, Your Lordship, because my colleague, she has difficulty as well, Your Lordship.
Okay. Both sides are represented. It is submitted at the bar that the pleadings have been exchanged. Expel on the prayer made by government advocate, list after 2 weeks.
Much obliged.
With pleasure. Lordship, I'd like to mention item number 7. Kindly allow us to file affidavit in reply to affidavit in opposition filed by respondent number 2 and 3, Lordship.
Okay. The both sides are represented. The learned counsel for the petitioner seeks adjournment to file affidavit in reply in the matter. Prayer is allowed, list after 2 weeks.
Congratulations.
Pleasure.
For admission, item number 3.
The vestibule will be asked for making a division bench list for this judgment.
Made it Your Lordship.
Yes.
On the last occasion, my father said took time for filing affidavit, madam. It's not available to me.
Oh, it has come. Okay. So. Just inform madam, whenever she's free, we'll sit down again. Where is that GST form of 16/9/2022, which page?
My lord. Yes, this my lord 32, my lord.
We'll have to go there, this can't be interfered. The authorities will have to determine. We can't take over the work of the authorities.
My lord, this similar issue was just came up for its honorable court and honorable court has passed an order, my lord. Principal benches, before the principal bench, the matter has come up, my lord, similar matter. Where court held that my lord TRC 01 cannot substitute so-called notice, therefore matter remanded back, granting liberty, my lord, to issue fresh proceeding, my lord, issuing proper notices as per required sections, my lord. That your lordship will find, my lord. Page 58, my lord. The others
this-
are not available. 58.
This is GST book. Which page is that form?
Rule is, my lord, rule 142 is the rule, my lord, and form and
142, yes, but the form is also here.
yes, no, form is also in giving, my lord.
GRC discharge, DRT 1449. 449.
This is page 449.
You've seen that? The High Court order of the principal seat,
Also, page 58 is the order, my lord.
58.
58 is the order. Question frame is at page 73, my lord. Question frame at page 73, my lord.
No, but in your case, it is justified because you were asked to show cause, but you did not do it before the authorities. That is at page 34, clause 4.1.
Yes, my lord, my case is, my lord.
Yes.
My case is, my lord. The proceeding initiated by form DRC 01 is not as per the act and rules of GST, my lord.
No, that
Because
also
section-
they will decide. Why should we prejudge it now?
That is,
If it is
my lord,
not there, you can always challenge it.
But now, my lord, this same question was came up before this court, my lord, and this court held, my lord, the proceeding cannot be set into motion by issuing form DRC 01. That is, and after granting liberty, this honorable also waived the period which have been used for the purpose of proceeding, my lord. For lordship will find it page 81 is the conclusion, my lord. Page 81, my lord. There are 29.
You see, against you, the allegation is also under section 74.
Section 74 and section 73, my lord, are similar. Requirement is also similar. And notice under section 74 is also required, my lord, to be issued, my lord.
Please, Lordship.
Yes,
Your Lordship, I'm representing the respondents here.
yes.
Lordship, I have received instructions, and as per the instructions, Your Lordship, the department has not given show cause notice to the petitioner, as they have stated. So in the light of the judgment annexed here at page 58.
But you are not filing an affidavit in opposition.
Yes,
These things can't be said orally. You'll have to file an affidavit.
Your Worship, if this matter can be remanded back to the department for a de novo initiative proceedings, Your Worship.
So you are conceding to his prayer.
Yes, Your Worship. Because we are not denying that we have not given show cause notice here. And filing of the affidavit will also be just consuming the time of this court.
Okay. Just show your instructions.
It's, Paragraph
But Mr.
that could.
A.K. Gupta and counsel for the petitioner, as well as Mr.
That could. Second counsel for the response.
Leonard CC appearing for all the respondents.
All the response.
Next one. The case of the petitioner is that the additional commissioner under the office of the commissioner, Central Goods and Services Tax, Dimapur, had issued a notice bearing number page 32, bearing number so and so, dated 16/9/2022. Thereby issuing demand come show cause notice bearing SCN number. It is there, down below. Alleging availing of the ineligible input tax credit projecting that the petitioners had claimed excess input tax credit within bracket ITC for short bracket closed, totaling rupees 52,88,894. And accordingly, relying on the letter issued to the petitioners as well as the GST returns filed for the period of January 2018 to March 2020 and GSTR-2 capital A returns of the petitioners for the same period, the demand was issued without prejudice to any other action that may be or already has been initiated against the petitioners under the IGST Act, 2017, CGST Act, 2017, and SGST Act, 2017, or rules made thereunder. Next para. Accordingly, the said demand cum show cause notice under form -GST DRC-01 dated 16/9/2022 is sealed in this writ petition filed under Article 226 of the Constitution of India. Next para, the learned counsel for the petitioner has submitted that he is relying on the judgment and order dated 29/6/2024, passed by this court in WPC 3912 of 2024 and connected writ petitions. Whereby it has been held that the initiation of proceedings under Section 73 of the GST Act cannot be validly initiated without issuance of a proper show cause notice. Whereby, amongst others, full stop. Next para. On the said point, the learned CGC has submitted that he has received. You are the departmental counsel.
Yes. Standing.
Okay. The departmental senior standing counsel
Yes.
has submitted that he has received written instructions dated 20/5/2025, inter alia, admitting that no prior show cause notice was issued to the petitioner. And he submits that he has instructions that the matter may be remanded back to the authorities for a initiation of an appropriate proceedings in accordance with law. Next paragraph. In view of the statement made by the learned departmental senior standing counsel, this writ petition stands allowed in view of the concession made. Rest of the event and show cause notice bearing SCN number, second one, by order number, this is first one, order number so and so, dated 16/9/2022, which is impugned in this writ petition, is set aside. First of however, the matter is remanded back to the assistant commissioner, additional commissioner, office of the commissioner, Central Goods and Service Tax, Dimapur, to draw up an appropriate to draw up an appropriate proceeding against the petitioner, comma, if so advised in accordance with law. Next, by the instructions produced by the learned departmental senior standing counsel is returned.
Madam, also interpret with page 41, madam, DRC 07. I am praying for setting sir both, madam. Page 47, 41, madam, I am also praying for interfering because pursuant to DRC 01, DRC 07 was issued, madam. Page 41.
Acha. That is number one. This is number two, page 41. Are both set aside. You write number two and consequential summary of the order. Under order in original, huh? Passed by the additional commissioner, office of the commissioner of Central Goods and Services Tax. The upper common agreement is are both set aside. Challenge will also be both.
Much approved.
Next. For admission, item number 4.
With Mr. Lordship,
Oh, this
making a prayer on behalf of my colleague.
this returned to him. Yes.
Yeah, Mr. Lordship. Yeah, in this item, Your Lordship, my colleague, she's appearing and she's here to file counter, Your Lordship, on behalf of the state. So Your Lordship may kindly grant some time.
How much?
3 weeks, Your Lordship.
2 weeks. Yes. Both sides are represented. The current government advocate pays for further 2 weeks' time to file affidavit in opposition in the matter. Next, as the petitioner projects that he has suffered dismissal from service, the state respondent shall ensure that the affidavit in opposition is positively filed within the time allowed. Next, the learned government advocate shall send a downloaded copy of this order to the respondent authorities to bring the order to their notice.
Much obliged.
For admission, item number 5.
May I please, Your Lordship?
Yes.
Lordship, here we have the instruction to appear for private respondent number 6 and 7, Lordship. We have filed our Bakalanama, Lordship. So kindly grant us 3 weeks time to file our counter, Lordship.
Yes, I was unable to follow why what is the why was this order by the Supreme Court of India is annexed? Page 26, Mr. Angami. This I could not follow. Why this Supreme Court order at page 26?
Yes.
Why this has been
No, Lordship. This is not challenge. This is not challenge, Your Lordship. What the petitioner is challenging is, they have been removed.
So they want restoration.
Yes, they want restoration, and according to them, they have gone up to the extent of the Supreme Court, and the amount that has been alleged to have been misappropriated by them has been utilized in filing cases before the apex court. So they have annexed this order to show that they have approached the apex court, man.
But the Supreme Court has dismissed it.
Yes, my lord.
You see, please come to page 2. You see, in the cost title, this name is not there. Because these things are a highly disputed question of facts. How can a writ court decide this?
No, Your Lordship, the only limited issue that need to be decided by this honorable court, Your Lordship, is whether the removal or the dissolution of the village council is as per the rules or not, Your Lordship.
No, but you see, why we have referred to this Supreme Court order
Yes.
is that they are now showing that they have spent money, 6 lakh rupees has been spent for advocate fees and all.
Correct.
And that is something which is, according to them, a misconduct.
Yes, misconduct.
Now, can the High Court go into that?
No, Your Lordship, but that was not the basis of how the council was dissolved. Actually, my lord. In fact, the council was not dissolved by the government, but the council was dissolved by themselves, Your Lordship, on account of the members resigning from their post.
Where is that?
Your Lordship, in my affidavit opposition.
Yes.
Your Lordship may see, starting from page 27, my lord, annexure I. Annexure I. These are the members of the village councils, Your Lordship, written to the commissioners, Nagaland, subject resignation letter from the post of village council members in respect of Linya village under Mon district. So they themselves actually have resigned from their post. This is how the village council was dissolved, actually, Your Lordship.
But dissolution must by the deputy commissioner.
Yes, and thereafter the order was issued by the deputy commissioner, which is under challenge.
That is why we are missing few things.
Lordship.
This document is not annexed here. And this is the letter of termination according to you.
They themselves resign, Your
No, we
Lordship.
understand, but
Yes.
according to you, this
Yes.
is the order
Yes.
which actually terminates their mandate.
No, Your Lordship, they themselves has dissolved the village council.
I understand.
And by an order that the 24th of February 2025, the government has dissolved the village, Your Lordship, village council. Madam.
Okay. Where is that order?
Your Lordship will find it at page 46 of the read. Page 46 of the read, madam. Type copy, Your Lordship will find it at page 47, madam.
Okay, now I get it.
Lordship.
There's some wrong reading.
Yes.
Okay, all sides are represented. The learned counsel for appearing for the private respondent numbers 6 and 7. Praise for is granted 2 weeks time, 3 weeks time to file their affidavit in the matter. List after 3
Your
weeks.
Lordship, may I please add interim state, Your Lordship.
What is the interim order?
Service notice issued.
Interim order passed on 27/3/2025 stands extended till the next date of listing. List after 3 weeks.
Obliged. For admission, item number 8.
Yes, Your Lordship. Here also, the state is yet to file affidavit, so on behalf of the AIM Lordship, my colleague, Your Lordship may kindly grant 3 weeks time to file counter.
How much time?
Weeks, Your Lordship.
3. Okay, both sides are represented. The claim made by non-government advocate, 3 weeks time is granted to file affidavit in opposition to the matter. List after 3 weeks.
Mr. Pledge.
For admission, item number 10.
That's right. This yesterday we made a mistake, I think. Spelling. Huh? This, if this is the spelling, yesterday in the order we are making wrong. Huh? Just show it to you. A spelling too. It was, huh? Yes.
May please, Lordship. Lordship, on 4th September 2025, this court has directed me to obtain instruction from the PNR as to why the matter was still very stuck in the State Department.
Yes.
I received the instruction from the PNR saying that the PNR has not received any official application from the Works and Housing Department for correction of details of the petitioner, Lordship.
But you know what has happened here? You have the earlier instructions to the government advocate. You have a copy of this. Show it. You have it?
Yes, Your Lordship.
Now, in this, you see, in this letter, this is a letter of 28/8/2025, forwarding letter,
Yes,
correct?
yes.
Here you say that they are in R1 category and therefore they are a minor mistake. After that, you can release their salary.
Lordship,
As per this letter, the petitioners are under R1 category. That means there are minor mistakes
yes,
in their names.
yes,
For that, there is a next document. These flags are there.
yes,
Now, serial number 96, 98, 99. This you say that this is the name.
yes,
Then next page, again this serial number 4, 6, and 7.
yes,
And after that, the last page is 163 serial number. Correct. Now, if these are minor, and this is the letters written in May 2023, then obviously you can't say that the.
No, Your Lordship, this is the letter is only addressed to the Secretary Government of Nagaland Works and Housing. But today is I'm representing the PNR. PNR, where on 9/4/2025, this court has implemented the PNR as a party.
The reason is only this. That's why we are showing it to you. You see, your what happens, the government must speak with one language.
Yes,
Correct. Now, one department says that they are working with us. There are some minor discrepancies. Once it is corrected, they will be salary will be released. Look at this letter, forwarding letter. Look at the forwarding letter. If they are not doing it, we will ask the government to pay interest.
no, Your Lordship, the petitioner,
Please look at this letter. Look at this letter. Second paragraph. The committee has verified the above categories. During verification, so and so it observed. Consequently, committee has divided the work employees into three categories. So and so, so and so. Next para. The next after 2 lines, fifth line. The employees who had minor clerical mistake in their documents are under category R1. Correct.
Yeah.
Now, third paragraph, last 2 lines. The petitioners are under R1 category as such until their case has been conveyed clearance by the PNR department for migration to A category. Their salaries cannot be released.
No, that's why, Your Lordship, I have this document which I received from the PNR.
So why you are not doing it?
That's why, Lordship, I have stated, Lordship, may kindly see the PNR letter dated 10th September 2021. What the PNR saying is, number 1, the PIMCEL PNR department has not received any.
We'll ask your chief secretary to have a meeting conveyed between the government of Nagaland, this PWD department, and the PNR department. Highest authorities will sit.
No, Lordship, in that case, Lordship, now what the PNR is saying is that we have not received any letter from the PWD department. And
That's why you see,
regarding with the correction of name, it is the PNR who will
No.
do. But for release of salary, it is the
you
department.
see,
It's
I
not the
have
PNR.
a different view. In that communication, which is sent to her by Engineer in Chief, Nagaland PWD, they say that they have written, you say they have not written. So we'll ask your authority to file an FIR against the Engineer in Chief. It's a misrepresentation. And we are today, we are asking suo motu contempt to be drawn up against these people as to why this discrepancy is coming.
Lordship, in that case, Lordship, give time for the respondent to file the affidavit.
We'll make it clear in the order. Because if they have not done, it is dereliction of duty. This Deputy Secretary of the Government of Nagaland, PNR department, shall lodge an FIR against the engineer in charge.
Lordship, that would amount to an excessive exercise of this.
Yes, we'll have to do it. He is
Excessive-
there without salary. And you said that the PWD says that we have written to a PNR. PNR says nothing received. Lodge an FIR. We'll use excessive power. You file a writ appeal. We'll give you that liberty. You'll have the privilege of arguing before the division bench on this matter. And we'll drop a contempt. We'll put it in the order. If you don't do it, after a week, we'll do all these two things. We'll give you issue a show cause notice to you why this should not be done. They can't play with the lives of these people. Which has represented Ms. V. Sukuri, an Additional Advocate General, appears upon instructions received from the Personnel and Administrative Reforms Department. And she has submitted that she is in receipt of instructions from the Deputy Secretary to the Government of Nagaland, Personnel and Administrative Reforms Department, stating that the PIMS cell of the P&AR department has not received any official application from the Works and Housing Department to date for correction of details in respect of the petitioners. Full stop. The contents of the letter dated 10/9/2025 is extracted below. Next paragraph. On an earlier occasion, when the matter was listed on 1/9/2025, Ms. Inaoli Leonard, government advocate, had appeared, appearing for the Nagaland PWD, had produced a communication dated 28/8/2025, written by the engineer in chief, NPWD, inter alia, stating that the employees who had a minor clerical mistake in their documents are under category R1, and that and further stating that the petitioners are under R1 category, as such, until their case has been conveyed clearance by the P&AR department for migration to A category, their salaries cannot be released. Full stop. It is further projected that the engineer in chief, NPWD, white letter dated 29/9/2022, has submitted documents with regard to R1 fixed WC employees under NPWD to the government for OM clearance And the government by letter dated 25/5/2023 has forwarded the observation of the PNAR department by letter dated 16/5/2023 to the engineer in chief. Full stop. The contents of the said letter is quoted below. Next para. From the above, from the contents of the above two letters, it appears that one of the authorities, one of the two authorities, i.e. the engineering chief, NPWD, or the deputy secretary to the government of Nagaland, personal and administrative response department, are making an incorrect statement before this court. Next para. Accordingly, we grant both the departments, i.e. the Nagaland PWD, as well as the Personal and Administrative Reforms Department, to sort out the matter between these two departments regarding the clearance of documents of the petitioners who are projected to be under R1 category. Full stop. Next paragraph. Both sides will, both the authorities shall take notice that as one of the two representations is found to be misleading, if both the authorities do not clarify as to which of the two contents of the two letters are misleading, the court, on the next date of listing, may issue process for initiation of contempt of court for misleading this court. Next para. Accordingly, the learned additional advocate general, as well as the learned government advocate, shall communicate a downloaded copy of this order to the engineering chief, first will be to the deputy secretary to the government of Nagaland, personal and administrative reforms department, and to the engineering chief, Nagaland Public Works Department, to sort out the matter between these two departments, and to exchange communication if so required for migration of the petitioners, who are stated to be under R1 category to A category. Next para. Give a date after 10 days. 7 days time we have given to them.
Lordship, next week I'll be out of station, so after 2 weeks, Your Lordship.
After 2 weeks. Okay, so make it 10 days here. 7 days time, make it 10 days. List on till the date. Two weeks you will not be there.
Fifth, Lordship.
25th. Okay, 25/9/2025.
Much better.
For orders, item number,
Additional educational record, 29/8 census kept as a year record.
Maybe see Lordship. Lordship here, the service upon respondent number 5 is awaited, Lordship. And Lordship, on last occasion, we were given the liberty to serve through Dusty also. However, Lordship, here they refused to accept through Dusty mode. And through AD, it's still awaited. And also, Lordship, we also sought to file a reply to the respondent number filed by the respondent number 4, and also to file additional affidavit, Lordship. However, our additional affidavit and also reply to the additional affidavit filed by the respondent number 4 is still in process. So,
For the first part regarding refusal by Dusty, that you
Yes.
have to file an affidavit
Yes, Lordship. In fact, they have not filed their opposition. They have filed only the additional, in the form of additional.
No, you are not getting the
affidavit.
point. For the Dasti, you will have to file an affidavit.
Yes, Lordship. We are waiting for the copies, Lordship.
Okay.
That is yet to be, we are waiting to receive, Lordship.
The learned counsel for the petitioner as well as the learned government advocate are present. Next, the learned counsel for the petitioners seek some time to file an affidavit regarding service of notice by way of Dasti. So she also prays for time to file affidavit in reply against the affidavit in opposition filed by the state respondents.
Lordship, not the state, private respondent number 4, Lordship.
Private respondent numbers?
4.
Number 4. Okay. Accordingly, matters stands adjourned today. List after
2 weeks, Lord.
2 weeks.
Lordship, there is an interim, Lordship.
No, there's no interim. It only says that the appointment of the private respondent shall be subject to further order of the court.
Yes.
Lordship, my apologies. Much obliged, Lordship.
For orders, item number 13.
May I please, Your Lordship?
Yes.
Lordship, service notice, issued to respondent to entry still awaited, Your Lordship.
Oh, you'll have to continue to wait. Just tell us how much, after how much time shall we list it? 1 year, 2 year, 3 year, 4 years? You're not even taken steps. The registry note says of 18/8/2025 that you have not taken steps for service of notice on respondent number 2 and 3. Now tell us, when shall we list it? Difficult question, no?
Your Lordship, after 3 weeks.
No, 3 weeks is time to take steps. No, we'll rather strike you out,
Right.
2 and 3.
Fresh step will be taken after 2 weeks time, Your Lordship.
Huh?
Fresh step to be taken after 2 weeks time.
After 3 weeks. No, then we are striking out 2 and 3. You have to take steps by in course of the day to day. You have the file with you. You have the file with you.
Your Lordship, I'm appearing on behalf of the living council.
No, but you have the file or you don't have the file? No. We give you time till Monday. Do it. The learned counsel for the petitioner as well as the learned government advocate are present. Next paragraph. Office note dated 18/8/2025 discloses that steps not taken for service of notice upon respondent numbers 2 and 3. Accordingly, the petitioner is directed to take steps positively within 15/9/2025 for issuance of notice on respondent numbers 2 and 3. Stop. The notice is made returnable on 23/10/2025. List accordingly. But be that as it may, what can be done if the department is closed? Your appointment was temporary. You shouldn't have permanent employment. And the department is closed. Okay.
Your Lordship, let an interview continue, Your Lordship. Interim be continued, Your Lordship.
Interim can't be considered because the Department of Hotel Management is closed. Where will you be employed? That's why we are asking you that question. That's why we saw that record for the time being to understand what the matter about. Your service was terminated. That's one good reason you should have taken steps on time. And the respondents have terminated your service on the ground that the Department of Hotel Management has been closed down. Now, how can possibly you be engaged? There is another reason why you should all be ready with this. Just give this specific relief act. Specific relief act. D, show it to her. Next page is D. This is 14. Correct.
Yes.
Read that first starting. Contracts which are not specifically enforceable.
The following contracts be specifically enforced, namely, where a party to the contract has obtained substituted performance of contract in accordance with the provisions of section 20.
Number 2, B, C, D. No. What you read is half. You are reading A, B.
A contract for the non-performance of which compensation in money is
Correct.
an adequate relief.
C.
A contract which is in its natural determinable.
D, next page.
A contract, the performance of which involves the performance of the continuous duty which the court cannot supervise.
So the contract which is terminable, you have temporary employment. It is a contract which is expressly terminable. Next page is D. Yes.
A contract which is in its natural determinable.
So that is D. So it is a contract which is terminable. And for that, what you can do under, at best you can do is ask for compensation for the for that period, notice period. Correct. So therefore, you can't get a relief. I'm not passing any adverse orders today. I don't want to discourage young lawyers. Okay.
For orders, item number 14.
But always be prepared. This specific relief act should be there in your head always. Yes. Service report is still not complete.
Lordship, it appears that my colleague Ms. Livika is handling this matter, Your Lordship. I think she is here to file.
No, 5 and 6 notice is not served.
Your Lordship, I think notice has already been served.
No. Show this to him. Office note. The counsel for the petitioner as well as the General Government Advocate are present. As per office note dated, what is the date? 99. What is the date?
Date.
Office note dated 99. 12/9. No. This date is this one. 9/9/2025. The service report on respond numbers 5 and 6 is still awaited. Next, but accordingly, the petitioner shall take fresh steps for service of notice on the respond numbers 5 and 6 by registered post with AD. Next, in addition, the petitioners are permitted to process the notice through the registry of the court and serve notice and the scanned copy of the writ petition with all enclosures to these respondents number 5 and 6 through email at the through email, the address of which shall be clearly mentioned in the steps to be filed by the petitioner. Next paragraph, the notice is steps within 2 days, 2 working days. The notice is made returnable on 25. Sorry, this is 24/10/2025. List accordingly. Take steps.
For orders, item number 15.
Me, please, Your Lordship.
Yes,
And I have instruction to appear for private respondent number 5.
number 5. Okay.
Can you grant me 3 weeks time to file our and on the affidavit?
Okay, how much time?
3 weeks.
Okay. All officers are represented. Miss,
Member Sharma.
just write it down. I'll make a mistake.
Yes.
Land Council enters appearance for respondent 5 and prays for and is granted 3 weeks time to file for Karatama as well as the affidavit in opposition. Full stop. Accordingly, they start after 3 weeks. This whenever madam is ready, just All these three petitions are dismissed.
Right.
Make it a file. Make it a file. There's some mistake which is crept in the order. While it is transferred from the other computer to this computer by pen drive, few letters have stuck together. So we'll have to detach those. That mistake has happened, I don't know.
Because of different version of the computer.
Yes,
Perhaps,
it happens.
perhaps.
All the letters got joined
Uh,
together.
they, so that mistake now we have seen while signing it.
Right.